thing I do want to, it doesn't require a court decision, but Mr. Reardon has asked me to make what is called an England Jennings reservation, which I have to look up, Your Honor. And it's basically, it's a reservation of a right to try issues that might involve federal questions or constitutional issues in a federal forum when that time arises. And I really have never heard of it, never raised it, but I looked at the law and it says that in order to invoke that right, if that right exists, if it applies here, you just have to make an announcement in the state court before the proceeding that might affect that right later. So Mr. Reardon has asked me to make that reservation, and I hereby am invoking his England Jennings reservation. I really think that leaves us possibly with just the recording and media coverage issue. I see that we do have a court reporter here. It was not at my request, but we do have a court reporter here. On top of that, Mr. Reardon has made his notice to the court that he is a member of the press and that he has invoked his right under the proper rules to provide media coverage of this proceeding, and ask for the court's permission to do so.
Hey, you gotta move that.
I'll move when I talk to Joey. Joey knows I'm out here waiting. He needs to come out and talk to me. I'll move when I talk to Joey. When Joey wants to talk to me, I'll move. Otherwise, I'm not breaking any law just for parking in a spot that says reserved for the sheriff's department.
One more time.
I'm here at the sheriff's department.
Move, or you will go to jail for disorder.
I'm not being disordered. I'm moving my car. I'm moving my car. I was moving my car. Ah! Really? Ah! I said I was moving my car. Oh! Stop! Ah!
I need to, and maybe I should have done it before breaking. I don't need to be on the record, but I'll start with the motion, and then, if denied, we'll begin our case. Under Rule 21 of the Mississippi Rules of Criminal Procedure, if I do not make a motion for a directed verdict now, I can't make it later, and an appeals court can't test the sufficiency or weight of the evidence. I'd like to move for dismissal based on the sufficiency of the evidence. The charge of disorderly conduct is 9735-7-1, which requires with an intent to provoke a breach of the peace under circumstances that may lead to a breach of the peace or which may cause a breach of the peace, the failure to comply with the lawful request or command, and subsection A is move himself or his vehicle, which I think this would fall under. But what it's got to be is a lawful request. There's kind of been an assumption that it's against the law to park in that spot or to park on the line of the spot. We can't find somebody criminally responsible based on an assumption. Part of the state's case was to prove that that was a lawful request, and they have failed to prove it. If the disorderly conduct charge is not good, then it follows that the resisting arrest charge must be dismissed, which requires a lawful arrest. If there was no underlying offense, then the arrest can't be lawful. On top of that, even if the arrest was lawful, there's not been sufficient evidence that Mr. Reardon was obstructing or resisting by force or violence. Deputy Dixon said, "I do not know if I said to put your hands up, to stop, or gave him any commands." He could not rule out the possibility that he did not. And without that, all we have is a deputy stepping towards a person who was lawfully standing in place and then moved to another place. Just like the deputy can't tell me where to conduct my examination, He cannot keep the defendant from stepping away from him. If he cannot testify beyond a reasonable doubt that he ordered him to stop, ordered him to put his hands up, ordered him that he was under arrest, then the resisting arrest charge must be dismissed, and also because the underlying disorderly conduct should be dismissed. Thank you, Your Honor.
Yes, sir. In relation to disorderly conduct, obviously, the sheriff, in addition to the jail, I would argue has a special need for security and safety for those who use that, for those that are housed in there. Against their will, I should ask. Nobody wants to be in jail. Nobody needs to be in jail. So the sheriff, in addition, is charged with keeping that facility safe, keeping that facility through all that enter it's safe. And I know there's some administrative offices there, but you've got prohibition. Says Sheriff's Department. I forget the exact quote. I'll allow them to with testimony of the Officer Dixon, who told us what it was there. Obviously, Mr. Reardon was there. He was parked in two spots, not just one. He was parked in front of that sign that says Sheriff's Department use or whatever the words were. In addition, he was parked over the line. Officer Dixon never asked him to leave. And I know that there was a time in questioning. Yeah, he was asked to leave. No, sir, you're not. He was not asked to leave. He was asked to move his car. Move your car. You don't have to leave. Move your car. And the answer was no. State feels that it's shown under 9730/71 disorderly conduct, a lawful request of the officer based upon the needs of that facility and of the sheriff's department. So hence, if you've got the lawful, if you've got a disorderly conduct and you resist,
if he cannot testify beyond a reasonable doubt that he ordered him to stop, ordered him to put his hands up, ordered him that he was under arrest, then the resisting arrest charge must be dismissed, and also because the underlying disorderly conduct should be dismissed. Thank you, Your Honor.
Yes, sir. In relation to disorderly conduct, obviously, the sheriff, in addition to the jail, I would argue has a special need for security and safety for those who use that, for those that are housed in there. Against their will, I should ask. Nobody wants to be in jail. Nobody needs to be in jail. So the sheriff, in addition, is charged with keeping that facility safe, keeping that facility through all that enter it's safe. And I know there's some administrative offices there, but you've got prohibition. Says Sheriff's Department. I forget the exact quote. I'll allow them the testimony of the Officer Dixon, who told us what it was there. Obviously, Mr. Reardon was there. He was parked in two spots, not just one. He was parked in front of that sign that says Sheriff's Department use or whatever the words were. In addition, he was parked over the line. Officer Dixon never asked him to leave. And I know that there was a time in questioning. Yeah, he was asked to leave. No, sir, you're not. He was not asked to leave. He was asked to move his car. Move your car. You don't have to leave. Move your car. And the answer was no. State feels that it's shown under 9730/71 disorderly conduct, a lawful request of the officer based upon the needs of that facility and of the sheriff's department. So hence, if you've got the lawful, if you've got a disorderly conduct and you resist, Your Honor, then you carry that scenario. As relates to the words, you're under arrest. I think an officer, he was unsure what he said, but then you started talking about this, and it's put better by the sheriff situation. The situation dictates the course of action. You've got the sheriff, Deputy Dixon, and this was confirmed by the other officer too, Officer Tidwell, looking at his reports, which is exhibit number 3 there, and he went back and read that correctly. He said, put your hand behind your back. And that's when he turned and made that motion to move away. And then with violence, it wasn't much violence this year. It wasn't a punch or anything like that. Officer, Mr. Driscoll went through those scenarios. But he was resistant the whole time, tensed up, wouldn't get up, he wouldn't move, he wouldn't. So, and the officer asked him, state feels that on both counts, it's proven this case, both cases beyond reasonable.
So,
Any other argument based on that?
no, sir, Your Honor.
I'm going to deny the motion for direct verdict. You ready to go forward with the defense?
Thank you, Your Honor. We call Mr. Reardon. Your Honor,
in that, if your client has any issues with including that language in the oath,
do you have any?
No, not at all.
Okay.
please raise your right hand. You swear to affirm the testimony you're about to give is the truth and whole truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right.
Your Honor, just asking you to make sure this is your voluntary decision to testify after consulting with me.
Yes.
Mr. Reardon, have we talked about your right to testify or to not testify?
Yes.
And you understand that you do not have to testify and that the judge would not take a negative inference from that if you didn't testify.
Yes, sir.
But you also have the right to testify and nobody can keep you from testifying if you want to. You understand that?
Yes, sir. It's true.
Would
Voluntarily.
you like to testify or not testify?
I would like to testify.
All right, is that your voluntary decision after consulting with me?
Yes, sir.
All right, Mr. Reardon, did Deputy Dixon ever tell you to put your hands up?
No.
Did he ever tell you to stop?
No.
Did he ever tell you you're under arrest?
No.
I'm talking about during the confrontation in the parking lot.
I never audibly heard the command, "You're under arrest." Never heard the command to stop.
Did you audio record that interaction?
Yes, sir.
And have you provided me a copy of that recording?
Yes, sir.
All right. May I? I'm going to play that the recording of the court. Once. I know it's just background noises and stuff, but Mr. Reardon, do you recognize that as a recording you took leading up to the events on December 28th, 2020?
Yes, sir. That honk was Deputy Tidwell locking his car after he got out.
Do you recognize whose voice that was?
That was Courtney Dixon.
Do you understand that that was a request to move your vehicle?
Yes.
I'm talking to Joe. Is that your voice, Mr. Reardon?
Yes, sir.
You have somebody here waiting. He needs to come out and talk to you. I'll move when I talk to Joey. When Joey wants to talk to me, I'll move. Otherwise, I'm not breaking any law. I'm just recording me in a spot that says preserve the sheriff department. I'm here at the sheriff's department. Move. Okay. But when it asked you, what did the sign say that you were parked in front of?
Reserved for Sheriff's Department.
Okay, and you just said you were there for what?
I was there to see the sheriff. In regards to my daughter,
I'll ask you about that in a second. Sorry to cut you off. But was it your understanding if you were there for the sheriff's department?
Just eating, Your Honor.
Yes.
Why did you park in that spot?
Hang on just a second, I believe there was an objection.
Objection to the lead.
I withdraw.
I think there's some background, but I'm going to object every time it's for.
Withdraw. Why were you parked in that spot?
I parked in that spot because the driver's side window was knocked out of my car. I did have a tarp there. Where I was parked, I could not hardly see when the sheriff was coming out through the rear view mirror. I couldn't see the side view mirror, and I simply wanted to speak with the sheriff because I couldn't get a response from him through email.
And why did you think that sign didn't prohibit you from parking there?
Well, there's the jail and the sheriff's department. If I figured the sign would have said for sheriff's deputies only. It had to have said authorized for official vehicles only or for sheriff's deputies only. I would have inferred it to be that. It's saying sheriff's department, reserved for sheriff's department. I was there on what I felt was official business to address the sheriff about a redress, about a grievance.
Matt, is that a true and accurate recording of the events we've seen on the Sheriff's Department's video camera from the jail?
Yes, sir.
Wait, can you just come on and talk to me?
Did you hear on that Officer Dixon give you any commands to stop, put your hands up, or anything like that?
No, sir, I didn't. And
What did you know? Did you know why he was stepping towards you?
I just felt as if a aggressor was coming towards me when I was simply trying to find the answer as to how this would be disorderly, when I wasn't acting in a disorderly way. So I thought that I was there to see the sheriff about my daughter.
Were you holding things in your hands?
I had my cell phones in my hands.
Listen to it one more time to see if we can.
I want to talk to Joey. When Joey wants to talk to me, I'll move. Otherwise, I'm not breaking any law just for parking in a spot that says reserved for the sheriff department. I'm here at the sheriff's department. Move. When you go in there, this one. I'm not taking this over. I'm moving my car.
In the report of Mr. Have you read Mr. Dixon's report?
I have.
In there, he says that you said, in quotes, no, 3 times.
That's correct.
Did you say that?
No, sir.
Just that recording confirmed that you didn't say those things.
Yes, sir.
In his report, it says, or in Tidwell's report, it says Deputy Dixon told Rick to place his hands behind his back. Did you hear that on your recording?
Not one time.
Did you edit that recording?
No, sir.
There's been some mention of some emails you had sent to Joey. Just tell the court what you were trying to get a hold of. I'm sorry, I'm being very informal, Sheriff East. Tell the judge what you're trying to get, Sheriff East.
Well, for approximately 12 months, the 12 months leading up to that, the mother of my minor child, who was 6 at the time, I had not seen her in 12 months. She had actually, prior to that, it was a false allegation of rape that was levied against me by the mother of my child, who then decided to live out a 12-month lie that Department of Child Services.
I oppose an objection. What's the relevance? We've got chancery courts in every county in this state, and not to mention Lafayette. We've got the luxury of having 2 chancellors here, and I think they'll give you an audience whatever you want as relates to child custody, child rearing, and the law, family laws, and marriage. I don't know why we've got to litigate that here, and I don't know, quite frankly, why he would be contacting the sheriff in that regard.
Well, I think if you'll let him answer the question, he'll tell you why he's contacted the sheriff. But as to relevance, there was suggestions by the sheriffs that he might have been there to ambush or do some bad. This goes to responding to that to show that his intention was not there to do any bad, but to try to enlist the law, as he had been instructed by another department of the state to do, in order to obtain some visitation rights.
I'm going to sustain as far as I don't want to go too far down a rabbit hole explaining any wrongdoing or what he feels, what is the reason for the issues. I'm fine with hearing why he was there.
Absolutely.
But I don't think I need a procedural history of what has gone over the past year to get that answer.
Sure. Well, bearing that in mind, that the judge has instructed you to, we ain't got to go into everything, but what were you there to do?
I was there because this was occurring in the sheriff's jurisdiction. It was not happening in the jurisdiction of the city. It was happening in the jurisdiction of the county. Therefore, the county sheriff holds, it falls into his care and jurisdiction and responsibility, if you will.
Was, to your knowledge, there anyone else on the out there in the parking lot when this event occurred?
No, sir.
All right. We have seen on the video when Officer Dixon kind of gets a hold of you, you kind of go into a defensive position. Tell the judge what you were doing, why you were doing that.
So in my left breast pocket, I had my digital audio recorder. I simply I wanted to retain the recording for the purposes of trial. So I simply had switched off the recording so that it saved the recording, and I wouldn't have to worry about it getting damaged or about anything worse happening to it.
What about, you had your cell phones in your hands? Did you, what'd you do with those?
Whenever I was taken to the ground, it was Deputy Dick. One of the phones had come out of my hand when I was tossed to the ground. The other phone, Deputy Dixon grabbed it from my hand and chunked it.
Hey, you gotta move that. I'll move when I talk to Joey. Joey knows I'm out here waiting. He needs to come out and talk to me. I'll move when I talk to Joey. When Joey wants to talk to me, I'll move. Otherwise, I'm not breaking any law just for parking in a spot that says reserved for the sheriff's department.
One more time.
I'm here at the sheriff's department.
Move, or you will go to jail for disorder.
I'm not being disordered. I'm moving my car. I'm moving my car. I was moving my car. Ah! Really? Ah! I thought I was moving my car. Oh! Stop! Ah!
What about, you had your cell phones in your hands? Did you, what'd you do with those?
Whenever I was taken to the ground, it was Deputy Dick. One of the phones had come out of my hand when I was tossed to the ground. The other phone, Deputy Dixon grabbed it from my hand and chunked it at the ground.
Did, when the recording ends there that we just listened to, that was because you manually turned it off?
Yes, sir.
All right, so you're in your chest working on your recorder.
Yes, sir. I just do my breast pocket. I just flip the switch to turn off the recorder. That's the way it saves the recording.
Okay. Now, you heard deputies or Sheriff East say that he had received some emails from you that day. Did you send him emails while you were sitting in the parking lot?
Yes, sir.
Do you want the court to see those emails?
I would like the court to see those emails. I think they're very relevant.
All right, Matt, I'm going to show you 3 emails.
Yeah, I'm going to propose an objection. He has agrees to that. There's emails there. Emails occur. I don't know what the substantive nature of any of those communications has anything to do with this court issue. We've got emails that were sent and pretty close in time to what's happening there at the Sheriff's Department. And I don't know how instant or what that proves as relates to trying to get in touch with the sheriff and how instant he got to respond.
Again, it's been implied that Matt was up to no good while he was there. We're just intending to show that he was trying to get in touch with the sheriff. He was in a distraught position over some matters, whatever they might be, and just wanted to talk to the sheriff.
I don't allow him. The sheriff testified that he received some emails that day. So assuming these are those emails, I don't allow those in.
I can't talk to you while you're staying. All right, are those the emails that you sent? Well, the first email, what's its date?
It was Sunday, the 27th of December, and
Is that the day before this incident?
subject criminal conspiracy.
Is that the day before this incident?
Yes, sir.
All right. And then the second email, what's its date? Give its time too, please.
Second email is Monday, the 28th at 4:32 p.m.
Okay. Was that sent before or after you got to the Sheriff's Department jail parking lot?
That was before.
All right. And then the third email, what's its date and time?
Third email is Monday, the 28th at 5:06 p.m.
All right. Was that before or after you got to the jail Sheriff's Department parking lot?
That was after.
We'd ask that these be marked as Defense Exhibit 1 or whatever number we're on. Actually, we ask that the recording, the audio recording, I'll have a thumb drive we'll get on there, be marked as Defense Exhibit 1. These be marked as Cumulative Defense Exhibit 2, please.
I'll move when I talk to Joey. Joey knows I'm out here waiting. He needs to come out and talk to me. I'll move when I talk to Joey. When Joey wants to talk to me, I'll move. Otherwise, I'm not breaking any law just for parking in a spot that says reserved for the Sheriff's Department.
One more time.
I'm here at the Sheriff's Department.
Move, or you will go to jail for disorder.
I'm not being disordered. I'm moving my car. I'm moving my car. I was moving my car. Ah! Really? Ah! I said I was moving my car. Oh! Stop! Ah!
Mr. Reardon, there were sheets in between after each email. Can you explain to the court what these sheets are?
Yeah, they're read receipts. Whenever it's acknowledged that the email has been received and opened, it gives the date and time.
Mr. Reardon, do you feel like you resisted arrest in that situation?
In no way.
You mentioned on that video that you said you would move your car, did you?
Yes, sir. I was
Offered to move your car.
Yes, sir. I really wanted to find out why it would be considered disorderly. I said that I wasn't being disorderly, and I was really trying to find out how that was being disorderly.
Were you ever told to get on the ground and lay down?
No, sir.
Were you ever told to...
To the leading, Your Honor.
Now, understand, I will draw. No further questions.
So you weren't moving your car, you were trying to get an answer to the disorderly. Is that right?
It was both. I was in the process. So you can see in the video, I turned towards my car.
No, we saw the video. You didn't go towards your car.
I shifted my shoulders towards my car.
Okay, well, I'll let the video speak for that.
Okay.
You got it.
Hey, you gotta move that. I'll move when I talk to Joey. Joey knows I'm out here waiting. He needs to come out and talk to me. I'll move when I talk to Joey. When Joey wants to talk to me, I'll move. Otherwise, I'm not breaking any law just for parking in a spot that says reserved for the sheriff's department.
One more
I'm
time.
here at the sheriff's department.
Move, or you will go to jail for disorderly.
I'm not being disordered. I'm moving my car. I'm moving my car. I was moving my car. Ah!